To another iTOOsday session. Today we are talking cyber. For those that are following the news, there's been some interesting developments around the cyberspace, particularly around the information regulator and the fines that are now starting to be issued. We started seeing the bill around POPI in 2021, and since then we've been asking the question, how will the fines actually play out? Who will be the recipient of the first fine? And now we actually have an answer. And to help us with this topic, we brought in a specialist team from Clyde & Co. Welcome to the gentlemen from Clyde & Co, Chris McRoberts, Lee Asbach, and Reese Martin. Thank you for joining us again for another session with iTOO, and we look forward to hearing a lot more from you. To our guests, to our brokers, please do share your questions in the chat or the Q&A. We will be monitoring. We've got our specialist from iTOO as well, Ryan van der Koolbeek, with us. Ryan just gave us the wave there. So he'll also be here to answer any sort of specific insurance-related questions. I'm here as well if you'd like to speak to me specifically. But yeah, so let's kick it off. Chris, over to you.
Morning, Luanda, and good morning to all of you on what, reading from the messages in the chat, seems to be generally a cold and fairly miserable day across the country, with the possible exception I see of East London. Thanks very much to Luanda and to the iTOO team for having us on here from Clyde & Co to talk about the cybercrime landscape, and particularly what we're going to be looking at today is cyber regulation and cyber enforcement. For those of you who read the news, you will have seen that 3 weeks ago, the information regulator issued its first fine against the Department of Justice. So we're going to be unpacking that for you today, talking about how that fine came about and what it means for you and your clients in terms of how the regulatory landscape in cyber enforcement is starting to shift in South Africa. This has been a long time coming, and so this is a significant development in the implementation of POPI, the Protection of Personal Information Act, and we look forward to going through it with you today. As always, we're very happy to take questions, so if you do have questions as we go through, please just pop your questions into the Q&A, and I know that we've kept some time aside at the end of the session to run through those. On a housekeeping point, I believe that we're about to go through a load shedding changeover in Sandton. So if we disappear from your screens for a few moments, just bear with us. The generator will kick in and we will be back with you in no time at all. So let's kick off. I'm joined this morning by my colleagues, Lee Asbach and Reese Martin. We work together in the Clyde & Co 1 cyber team. And we're very fortunate to work with iTOO and with its policyholders in managing and resolving cyber incidents, both in handling incident response and in advising policyholders around their obligations in making reports to the information regulator and to other authorities when it comes to dealing with the aftermath of cyber incidents. I'm going to start by taking you through just a high-level look at what the cyber enforcement landscape in South Africa looks like, both in terms of the statutes and then a couple of other sources of liability. And then I will introduce you to the key role players when we come to talking about enforcement. Reese is then going to take you through the information regulator's powers to investigate, and he's going to roadmap for you the different avenues to enforcement that come up. So it's an important point to make at the top of the session that fines from the information regulator don't just come out of nowhere. They come at the end of a process, a fairly rigorous enforcement process. And this recent fine that we've seen against the Department of Justice is a perfect example of how that process has played out over a number of months. We'll then just talk you through how the enforcement process works with the enforcement committee and what tools and enforcement actions are available to the regulator. And then Lee is going to talk you through the specifics of the DOJ fine, how it came about, what mistakes were made by the Department of Justice in its dealings with the information regulator, and probably what lessons that holds for us in the private sector and generally for corporates in South Africa. I think Ryan may then share a couple of insights with you around the iTOO policy and some considerations relating to security, if we have time, and then we're very happy to move to a Q&A. So that's what we're going to be going through. and we look forward to taking you through it. So this is not intended to be a dense session talking about provisions of acts and bits of legislation. We will, of course, need to talk a little bit about POPI and the Cybercrimes Act, but I'm sure that all of you will have been in various training sessions where you speak about POPI and the conditions for lawful processing and so on. So we're not going to spend a huge amount of time on that. Just as a quick refresher in terms of what POPI is about, the Protection of Personal Information Act serves mainly to give effect to the constitutional right to privacy by safeguarding personal information. And the terms that are used under POPI are a responsible party, which is the primary entity which is processing personal information, and the operator, which may be the secondary entity, which is on the other side of the processing transaction or arrangement. So just to bear in mind those terms, we will come back to them a little later in the session. So POPI is the main data protection instrument in South African law. It regulates the way that personal information is processed, and importantly, it provides rights and remedies to affected persons. And we're going to be spending a little bit of time on those rights and remedies today. All responsible parties must ensure adherence to the 8 conditions of lawful processing of personal information. We've gone through those in previous sessions, so we're not going to dwell on them today, but those are the main pillars of how personal information should be handled in terms of POPI, and those kind of paint the lines on the field, if you like, for when we're looking at enforcement and whether the conditions of lawful processing have been breached, which may give rise to enforcement actions. So in a nutshell, that's what POPI is about. One important point to put across, which differs from data protection instruments in other countries, is that it is important to understand that in South African law and under POPI, personal information means not only information of individuals like you and me, but also the personal information of juristic entities. So companies, trusts, any other juristic entity that has separate legal personality also has personal information which needs to be processed subject to the Act. And that is a point that is often misunderstood when we speak to clients about what processing means. So the South African data protection landscape is broader than many other jurisdictions because of that extension of personal information to juristic entities. And that means that when we're talking about enforcement action, if in a business-to-business relationship, there is a failure to process personal information properly, it does mean that there could be enforcement action, which comes from that. So POPI is the cornerstone of data protection in South Africa. I'm sure that you're familiar with it. If you haven't read the Act, that's okay. We'll take you through the main features. And that's what we'll be talking about in enforcement terms today. We also just wanted to flag to you the Cybercrimes Act. Now, the Cybercrimes Act is a more recent piece of legislation passed in 2020, and it creates offences and imposes penalties for certain types of cybercrime. For example, the distribution of harmful messages, whether they're on email or WhatsApp. Cyberbullying is criminalized, cyber extortion is criminalized, and it provides for a range of remedies like protection orders and various criminal sanctions. So the Cybercrimes Act is intended to create criminal remedies which didn't previously exist in our law, and it also creates reporting obligations for victims of cybercrime. Those are still in the process of being worked out, but what we do see when we're dealing with cyber incidents like ransomware attacks and so on, is that we need to look at the reporting obligations created by the Cybercrimes Act when it comes to making reports. So just to explain the distinction in terms of who's in charge of things under the Cybercrimes Act, as opposed to POPI, the South African Police Service is the main authority in charge of maintaining and ensuring compliance with the Cybercrimes Act. And that differs from POPI in that the information regulator is the main institution responsible for upholding and enforcing POPI. The information regulator has in the past recommended that security compromises under POPI are notified to the SAPS. And the information regulator had made a habit of doing this well before the Cybercrimes Act was enacted. We have been consistent in our advice to clients that where there is an act of cybercrime, it is important to report it to the SAPS.
Apologies, everyone. I think the Calico team are just going through some load shedding, but they should be back with us momentarily.
Sorry about that, Rwanda. Can you guys hear us?
Loud and clear. Thanks, Chris.
Oh, good. We come blinking from the darkness back into the light. Sorry about that. Sorry about that disruption. Can you still see the slides?
No, please reshare, Chris.
Okay, no worries. Let me get those back up for you. Just bear with me while I find them. All right, hopefully you can see the screen again and we can continue on our merry way. Sorry about that interruption. So I was just contrasting the sort of enforcement mechanism under the Cybercrimes Act, which is regulated by POPI, and the POPIA enforcement process, which is overseen by the information regulator. Section 54 of the Cybercrimes Act is just important to flag to you. That creates a time-limited reporting period for certain cybercrimes. It's not yet in force, but it is just important to understand that because it may have bearing on criminal reporting in due course. And then, as many of you are brokers and work in a highly regulated environment, it's important to flag to you financial sector specific obligations. So regulated entities such as brokers or financial advisors need to pay specific attention to financial sector laws, which may apply in the event of a cyber breach. A licensed financial service provider is required to report a breach to the responsible authority if the licensee contravened a financial sector law in any material way. And it's important in the context of a cyber attack for financial service providers to consider their own governance and risk management policies. So again, we're not going to go into the detail on this, but it's just important to say that as regulated entities, there may be additional reporting requirements beyond POPI, which need to be considered. Okay, and then I'm just going to briefly walk you through what the reporting process looks like for a security compromise under Section 22. In much of the breach response work that we do in the Clyde & Co team, we advise clients on reporting of security compromises if they've suffered a business email compromise event or a ransomware attack or any similar breach of their systems which has led to data being encrypted or taken out. Section 22 of POPI sets out what is required when reporting a security compromise. And here we've just given you the who, what, the why, who, when, how, and what of what needs to happen there. And we will share these slides with the IT team after the session so that you can hang on to this. So why does reporting need to take place? Well, where there are reasonable grounds to believe that the personal information of a data subject has been accessed or acquired by an unauthorized person. That would mean that a security compromise has taken place. And I'll go back here to what we said at the top of the session around what personal information means, that the personal information of a data subject may relate to a natural person, or it may relate to a company. And all of that needs to be considered in the context of a security compromise. To whom does your reporting need to be made? Both to the information regulator and to data subjects. And in a moment, Reese will talk you through the reporting process to the regulator and what kind of detail needs to be provided. What do data subjects need to be told, and how should they be told? Well, they need to be notified in writing, and there are several different communication methods for how they can be notified. Email, by physical or postal address. It won't surprise you to hear that we never advise our clients to send postal notifications because we have no confidence that they will arrive. A notification can be posted on a website or published in newspapers or the media. So for any of you who receive notifications in any of the larger, more public cyber incidents in the last year, TransUnion is a good example of how notification took place through several of those channels. And when does it need to happen? As soon as reasonably possible after the discovery of the compromise, unless making notification to a data subject will impede a criminal investigation. So it's important to say that POPI doesn't set out a specified time period for reporting, which is different to other pieces of legislation like the UK Data Protection Act and the GDPR in the EU, which has a 72-hour reporting threshold. POPI just says that it needs to be made as soon as reasonably possible. And we typically advise our clients that you need to be able to scope and understand the extent of a breach to determine that a security compromise has occurred. And once you've crossed that threshold, reporting should then be made. So just that gives you a view of security compromise reporting. And that is really the first step in the process of notifying the regulator that something has happened. I'm now going to pass across to Reese, and he is going to talk you through the who's who of POPI enforcement, and then take you through the enforcement channels.
Thanks, Chris. I think if we can just move to the next slide, I'm sure it's coming up.
Have you got the who's who slide there, Reese?
Yeah, I've got it now. Thanks.
Okay.
Yeah.
Good.
So the key, so and I understand a lot of the people and attendees on the call have been through many an intro to POPI course, but it's important to revisit kind of key concepts, especially since we're moving into a discussion on enforcement action. We thought it would be helpful to share, just some brief background on the two kind of role players in the enforcement process, who kind of contribute to the monitoring and investigation of non-compliance under POPI. So as Chris has been saying in terms of Section 22 and who that notification needs to be made to, the kind of central body and regulatory authority for data privacy in South Africa is the information regulator. It's accountable to the National Assembly only, and it has been established under POPI to monitor and investigate and ensure compliance with POPI. The current chairperson is Advocate Pansi Kula, and she is assisted by 4 other members. They make the kind of core body of the information regulator. Then a kind of subset body under the information regulator is the enforcement committee. You would have seen last year, towards the end of last year, there was a notification or publication rather that the enforcement committee was finally established. Based on that media statement, it comprised of 14 independent experts chaired by an advocate, and its kind of role and body is to really assist the information regulator in coming up with appropriate fines penalties and enforcement action once an initial investigation has been done by the information regulator. So keeping those two kind of bodies in line and in mind whilst you're going through your compliance journey, those are the kind of two to look out for if there's any sort of engagement needed with the information regulator. We can move on to the next slide. In terms of how the regulator becomes aware of non-compliance, Chris focused on the Section 22 notification process. That's the main kind of avenue where they are informed of potential non-compliance with the protection of personal information. We also know that there's a complaints process, the regulator is also empowered to conduct their own initiative investigations. Going back to the Section 22 notification, they've established a formal reporting form that's available on the information regulator's website, and that really it's quite a helpful document in showing what's the level of information that needs to be provided. Once the responsible party has made the decision, or who's had reasonable grounds to believe that data subject information has potentially been acquired or accessed. One of the kind of interesting aspects of the security compromise notification form is that it requires responsible parties to sign the form when submitting it to the information regulator, and it has a tick box mechanism for when responsible parties believe or allege that there's a security compromise which hasn't been confirmed. So there's kind of a decision to be made at that point whether you only suspect a security compromise, whereas you at that stage, or you can confirm a security compromise. In my view, that kind of assessment that Chris spoke about having reasonable grounds to believe, it might be kind of an overreach by the regulator to say that you need to report when there's only an alleged security safeguard, because Section 22, which is the actual section under and arguably the law under POPI, requires you to only notify when there's reasonable grounds to believe. So there's a bit of kind of a gray area between what the report requires you to do and what Section 22 requires you to. And that's just something to keep in mind while you're completing that form. What we always recommend is to really take a step back once you understand that the security incident might have taken place, and really understand, at this stage, what kind of information can you share to the information regulator that will keep them, apprised of the developments, and what steps you as a responsible party are taking to address the cyber incident. Focusing on three key areas is really describing the incident in as much detail as you can at that stage, explaining the steps taken to mitigate from the incident, and giving a rough sort of assessment of the data subjects impacted by the incident is kind of the three key areas of the security compromise notification. And what we've kind of been doing in our practice is really making sure that we keep the channel of communication open with the regulator, and making sure that if there's any additional information that needs to be provided, post the initial notification, that we make a further supplementary notification if appropriate. So by no means, the form is helpful guidance, but the real aim is to keep the regulator notified, and the supplementary notifications might be appropriate in that sense. Just moving along to the complaints process, this is another way the regulator kind of keeps. You can go back to the previous slide, Chris. Under Section 74 of POPI, data subjects are empowered to make complaints to the regulator, which may trigger an investigation. Be mindful that the POPI requires the information regulator to conduct a pre-investigation, which is just to understand at a baseline what the complaint relates to, giving an opportunity to the responsible party to answer the complaint. And then the regulator may investigate officially, or it may take a decision then not to investigate further, or to be content with how the responsible party has addressed the complaint, or has addressed their non-compliance with POPI, their potential non-compliance. We've had an issue where a data subject has made a complaint to a responsible party that we were acting for, and it was really a kind of correspondence kind of exchange of letters between the information regulator and our client to really showcase the measures that had been put in place post that complaint being made. And the regulator took a very pragmatic and reasonable approach in our view, and sided with the responsible party and said, based on the evidence at hand and the nature of the complaint, they found that the kind of potential contravention to data privacy rights wasn't as harmful as alleged by the complainant. So we're seeing that they are utilizing these mechanisms, and it's good for responsible parties just to be aware that data subjects are empowered to make these complaints. The regulator is actively investigating complaints and making sure that responsible parties are answering any complaints made. And a key concept on the complaints process is really the interference with the protection of personal information, and that we can see being drawn in the enforcement notices that we'll touch on a bit later. But it's really, the regulator is really there to understand whether there's been an actual interference with personal information, and how, and to what level has that interference been done, and how can it be corrected by the responsible party by enforcing certain security safeguards or assessments or policy development, for example. Lastly, the regulator, and this is one that we're seeing often now, is that the regulator is going on of its own accord, as it is allowed to, and is actively investigating on its own initiative. And we see that in cases where there's been great media buzz around an incident, and there's been no Section 22 notification, which notably is directly non-compliance with POPI, and recognized directly as an interference with protection of personal information. And that's why the regulator is empowered to investigate of its own accord, because sometimes the measures aren't properly complied with, or the notification measures aren't properly complied with. So keeping in mind that the regulator does not need to wait for a notification, does not need to wait for a complaint, is key to understanding that there can be proactive investigation by them, and making sure that you respond timeously is one of the best kind of ways to keep the regulator on side during an investigation. I'm just moving on, Chris. Next. There's a bit of feedback. I'm not sure where it's coming from. But in terms of the information regulator's powers to investigate, the four kind of terms I would like to leave the audience with is really understanding the kind of tools that the regulator has under its belt to make sure that they investigate non-compliance quite swiftly. The information notice is a mechanism that is under POPI, and it empowers the information regulator to call for information that has not been provided. For example, in the SAPS incident, the regulator issued an enforcement notice. It was one of the first ones issued, calling for a response by the SAPS in relation to the Krugersdorp rape case. That basically requested evidence of POPI compliance and certain policies, and confirmation of certain presumptions and beliefs that the information regulator had in terms of the processing of personal information, and the lack of protections put in place. Summons and warrants are recognized under POPI. For example, the regulator is empowered to issue a summons. Again, this was done in the SAPS incident, where the information notice wasn't complied with, which resulted in a summons being issued against members of the SAPS to respond. And then equally, warrants may be issued. The POPI recognizes that the regulator may approach the court to issue a warrant to assist in its investigation into potential non-compliance. Enforcement notice, that's one of the big reasons why we're here today. This is really where the regulator may issue an enforcement notice and compelling compliance with POPI. This is where the kind of investigation has ended and has culminated into a discussion potentially with the enforcement committee, and is kind of developed into an enforcement notice, which includes a discussion on the incident, the findings of the information regulator, how the information regulator felt that there was non-compliance with Section 19, for example, which is the security safeguard, Section 22, which is the failure to notify the information regulator. So it really is kind of a long guidance document, and takes you through the investigation process, and it shows insights into what the regulator is looking for and where the regulator has found fault with the responsible party in relation to its protection of personal information and compliance with POPI. And then lastly is the infringement notice, which is really if there's been non-compliance with an enforcement notice, the regulator is empowered to issue a sanction or fine, which fits under the infringement notice as the administrative penalty. And I just want to pause there, because you'll see from the enforcement notice to the infringement notice, there's a lot of time and engagement and opportunity with the information regulator, and provided by under POPI to ensure that the sanction and the administrative penalty is kind of the last kind of port of call before a fine and something that's a financial sanction is levied, and keeping that in mind, that the compliance is a two-way street. The regulator may investigate, but there is ways to get out of a fine, or to make sure that all the information is put in front of the regulator, so it's not kind of wound up to be a fine, is very important to note. We've had many queries to say, can a fine be levied as soon as there's an investigation? And that's generally not the case, because the regulator must have a body of evidence and must engage with the responsible party. And what we're seeing is that information regulators taking very good steps to ensure compliance through security measures and compelling, certain security measures to be included in their data protection journey, and then monitoring that. And if there's failure on that side, or if there's failure to implement any of that or to provide any proof, then it leads into a kind of administrative penalty infringement notice discussion. And at that point, I'll hand over to Lee to discuss the very DOJ cyber incident. Thanks, Lee.
Morning, everyone. I hope you can all hear me okay. Firstly, let me just say again, to reiterate Chris's opening comments, it's always wonderful to participate in these days with our colleagues from iTOO. It never ceases to amaze me. I've been watching the number count of participants, and I see we've just broken the 600 participant barrier, and I see that we have people as far afield as Australia dialing in. And that's interesting, because our team here at Clydes have worked very closely with our Australian colleagues and our colleagues in the UK, who operate in highly regulated environments where, as many of you will know, there have been significant data breaches and some very hefty regulatory fines that have been dished out by the regulatory authorities in those jurisdictions. And lo and behold, we now find ourselves in what we think is the start of a very similar landscape here in South Africa, in terms of the enforcement action that our regulator is empowered to take under POPIA. As many of you know, we have seen in the last sort of 12 to 18 months an explosion of ransomware and malware attacks on a broad range of targets. It's indiscriminate, it's SMEs, it's schools, it's tertiary educations, it's those in the insurance and the financial services industry, and it's across the board. And before we get into this rather interesting case study on the Department of Justice, I think it's fair to say that with that massive explosion of cyber attacks in sort of the last 12 to 18 months, we have seen signs that our particular regulator is keen to flex their muscle in terms of the very significant powers that have been granted to them under the Act. And Chris and Reese have both alluded to that. So what we've seen initially is the own initiative assessment powers that the regulator is granted under the Act. What's interesting about that, to the point that Reese has made, is that it's not just in connection with those responsible parties that have not given notification of a cyber breach under the Act. But what we've now seen is that following a report to the regulator of a cyber breach in terms of Section 22, instead of getting a rather bland one-line response where they acknowledge receipt and they give you a reference number, we've now started to see them conduct these own initiative assessments, which in our experience is very intensive. And what our clients have been faced with is an extensive array of very deep searching questions, drilling down into the client's IT environment and asking questions around the IT infrastructure, their architecture, the flow of information, what security measures they had in place, and really going into detail in terms of how the particular breach arose. And it's a very technical exercise. It requires the input of the client's IT personnel and external providers such as forensic investigators in order to deal with those inquiries. And I mention that because it shows in our view that the regulator has started to gear up in terms of its own technical expertise to have a closer look at these types of cyber incidents. That's the one thing to bear in mind. The other thing we saw before we get onto the DOJ example, and again, Reese has mentioned, we've seen the regulator issue summons on parties, calling for them to provide information around breaches. So again, the example used of the South African Police Services. For those of you who don't know, again, as Reese has mentioned, SAPS created a WhatsApp group, and for whatever rhyme or reason, published the personal information of various rape victims, the Krugersdorp rape victims, on that WhatsApp group. And in that particular instance, the regulator issued an information notice calling upon SAPS to provide further details about that WhatsApp group. So what was the purpose for which it was set up? Who were the participants on that group? What was the personal information that was shared on that group? Whether that personal information was shared on any other medium and the like. And that particular matter ended up where the regulator actually directed SAPS to issue an apology to the affected persons. So we've had some precursors to what we've seen with the DOJ to indicate that our regulator is starting to flex its muscles in terms of the enforcement powers. And we then land with the DOJ and the fine that has been dished out to them in the last 3 weeks. Chris, if you could flick to the next slide. So essentially what happened here, just in summary, is that the Department of Justice fell victim to a cyber attack in 2021. 1,200 files were lost, and internal documents and personal information was compromised. And the DOJ had essentially failed, as we now know, to comply with its obligations in terms of POPIA relating to security safeguards. And in particular, what the DOJ had apparently failed to do was to renew their antivirus software, which included an intrusion detection license that would have made them aware of the unauthorized access to their network. And of course, as we know under POPIA, responsible parties must implement appropriate security measures to ensure the integrity and the confidentiality of their personal information. So following the cyber attack, a notification would have been made to the regulator, and the regulator then started to analyze exactly what had happened within the DOJ. Chris, if you can move to our next slide, please. So in this particular instance, following an investigation, the regulator issued the department with an enforcement notice, in terms of which it ordered the department to ensure that its antivirus and intrusion detection licenses were to be renewed within 31 days of the issuing of the enforcement notice. Now, if I can just pause there, an enforcement notice it's a significant step in terms of POPIA, because essentially it is a directive by the regulator, which, as we understand, has the force of law. So as a responsible party, if you are met with an enforcement notice, which is served on you by the regulator, you are lawfully required, to comply with that notice. And the Act sets out various particulars that must be contained within the enforcement notice. So, for example, there must be a description of the unlawful processing or the interference of personal information as deemed by the regulator. There must be particulars around the right of appeal that is granted to the responsible party in the event that they are met with an enforcement notice and for whatever reason they do not agree with it. So the Act uses language like the serving of the enforcement notice. So it has, as I say, it sounds very similar to the serving of a summons. It's a directive that you are required to comply with. Once you as a responsible party are met with that enforcement notice, if you disagree with it, you have to take formal steps in terms of POPIA. So you can formally apply to the regulator to have the notice varied or cancelled or set aside, or alternatively, you have to take it on appeal to the High Court of South Africa and apply to have the notice set aside. So that's why we say it is a directive that lawfully you must comply with in order to ensure that you don't suffer further sanctions that may be dished out by the regulator, which is exactly what happened here. So the DOJ was met with an enforcement notice where there were all these recommendations made. One of the other recommendations that was made, which is very interesting to us, is the fact that the regulator went so far as to say that the department must take disciplinary action against those employees who were specifically tasked with the responsibility of renewing the antivirus software. Now, of course, many of the brokers in the virtual room today who sell director and officers' liability policies, that will catch your attention, because there is a very good illustration of where the focus can shift from the responsible party itself, the company, onto the individual directors and officers of the company. So that is an aspect that we are going to watch very closely as we move forward to see whether the regulator continues in this vein to take steps directly against the individual directors and officers of the company, and of course, the information officer who is tasked with the responsibility of ensuring compliance with POPIA. So that was a very interesting aspect to the enforcement notice. What happened here is that the regulator then warned that a failure to adhere to the enforcement notice would result in further sanctions. And as Reese has explained, that then comes in the form of an infringement notice. And in this particular instance, for whatever reason, the department failed to comply with the directives in the enforcement notice. They ignored it. There was no response, as we understand, to the regulator. And that then triggered the next step in the process, which was the issue by the regulator of an infringement notice, which included an administrative fine. Now, under POPIA, in terms of Section 109, the regulator is empowered to administer an infringement notice, and within that, to incorporate, amongst other things, an administrative penalty subject to a maximum limit of 10 million rand. And in this particular instance, they imposed an amount of 5 million rand on the Department of Justice. So it is the first illustration or the first example of an administrative fine that has been imposed by the regulator, and it results directly from the department's failure to adequately deal with the enforcement notice that was issued on it. So to Reese's point, just in terms of some takeaways, and Chris, you can flick to the next slide, please. I think what is apparent from this is that you ignore the regulator at your peril. If you put your head in the sand and you don't do anything, it's now clear that this particular regulator is going to take further steps to make an example of that responsible party. So it has become very much a situation where you need to be proactive in terms of dealing with these cyber breaches. And of course, that's why the advantage of a cyber policy, and when you as brokers speak to your clients about why it's so important to have a cyber policy, this is the perfect illustration of that, because it allows the responsible party access to people and personnel and the means to deal with the cyber breach in a proactive manner, to make a timely report under Section 22, and then, if faced with further scrutiny from the regulator, either in terms of an own initiative assessment or an enforcement notice or the like, that you then have the means to deal with these very, very complex issues, and hopefully ensure that you do not walk the path that our Department of Justice has done, which lands you up with the prospect of an administrative fine. What I would also just mention briefly, because some of you might be wondering, the fine itself has the force of a civil judgment. So the regulator can submit a statement to a court having jurisdiction, setting out the details of the fine, and the Act specifically states that it will then be treated as a civil judgment. So theoretically, at least, it means that the regulator can issue a writ in order to give effect to that. So it will be interesting to see if we see sort of some movement in that regard in due course with those that ignore the administrative fines that might have been imposed on them. You might also be wondering where the money goes. The fine itself is paid into the National Revenue Fund. That is the fund where all of us good citizens pay our taxes to, and that fund is then used for the benefit of local and national government. So that is where the fine has been paid. So in summary, it's a significant development for us because, as we say, it shows that the regulator is serious about enforcement. Under the Act, they are serious about those that ignore enforcement notices and the like and do not cooperate with the regulator. And I think if I could leave this last point with you, this heightened sense of regulatory activity becomes very important when one bears in mind that under the Act, data subjects can institute legal proceedings for damages on the basis of strict liability. They do not need to prove intent, and they do not need to prove negligence. And the Act empowers our courts to grant awards that are just and equitable in the circumstances. Now, we don't know what is meant by that, just and equitable in a POPIA context, and only time would tell. But the Act goes even so far as to say that the court may grant aggravated damages. So this type of regulatory activity, aside from the fact that it results in regulatory fines, might also trigger civil action by affected data subjects, where they might well pursue those sorts of onerous awards for damages in the court. So we live in interesting times. It's a significant development, and hopefully our insights today have given you some sense of where we think we are going as a jurisdiction, which, as I say, will probably take us down the road of what we've seen in other international jurisdictions, such as Australia and the United Kingdom.
Thanks very much, Lee. Well, hopefully that gives you some insight into what's going on and the kind of matters that we're dealing with on a day-to-day basis. I'd like to hand back to the iTOO team just to facilitate the Q&A and to make any comments in closing.
Thanks, Chris, Reese and Lee. I think very insightful. I was feverishly taking some notes down on my side, so a lot of good insights. I was going to chat one or two things on the security front, but I think possibly worthwhile trying to score some free legal advice while I've got you guys on the line, because I think that's what Q&A directly translates into. There was quite a good question that came through from somebody who will be well known to yourselves, Nadia and our claims team, who was saying, any sort of guidance or insights that you can share, having seen a number of these incidents now, on what people should refrain from doing in both the public sphere as well as from a regulatory point of view in responding to an incident?
Yeah, it's a great question, Nadia. I'll take the first bash at that, and I'm sure that Reese and Lee will have comments as well. I would say that the misstep that we encounter most often when we're dealing with cyber incidents is that once we've handled the initial, what we call the triage phase of getting on top of an incident and managing it and understanding what data may have been affected, companies then typically take their foot off the gas when it comes to reporting to the regulator. They don't see that as being as important. And in the worst cases, we've dealt with boards that simply say, we're not going to report, we're going to stick our heads in the sand and move on from this as quickly as we can. And that's probably the biggest mistake that can be made, because yes, it's a chore to report, and you may take the view that, well, the regulator is not going to find out about this if we don't tell them. But the risks of not reporting are significant. And as we see this enforcement action ramping up and more of these fines starting to come through, the risks of these fines being imposed to private entities, and as Lee said, on the enforcement actions being extended to individuals who are specifically singled out for their failures, those risks are great. Lee, what do you say?
Yeah, thanks, Chris. I think from my side, probably one of the biggest takeaways we've had recently is consistency in messaging. So it's very important that a responsible party that has been the target of a cyber incident, that there is a consistent message in terms of what is happening, is issued to all the various affected parties and persons. So the data subjects themselves, the regulator, stakeholders within the business, shareholders, customers, suppliers, and the like. And I think what we have seen just on a practical step is that responsible parties can get into difficulties if there are different messages going out about a particular incident, because that inconsistency can cause problems when those, such as the regulator, comes to scrutinize what's happening. So again, back to the benefits of a cyber policy, and the fact that the responsible party is afforded the access to public relations experts, cyber experts, legal experts. That's all important, because those teams work together to ensure that the messaging around the incident is right and proper and that it's consistent. Because again, as we've seen with the regulator, what you report at the outset is going to be looked at more closely. They have the technical means now to analyze what you're putting up, and thus the messaging becomes imperative in any particular instance.
Absolutely good point, and we can't agree more. Is to ensure you get that level of consistency in the messaging and that you approach your response appropriately. One of the big pieces of advice that I'd love to put out to the brokers is, if your client has got a cyber insurance policy, you really encourage them as much as possible to let the insurer, or ourselves, whichever insurer they've got their policy with, know about that incident as soon as possible, so that you can have the best resources to address the situation, both from an IT sort of technical perspective, the legal perspective, the PR perspective. All of these things do combine to reduce the impact and damages to the business and those who have actually had their data compromised from that. So really important to get the right guys on the ground quickly. A little bit of a tricky question to throw out, and I've seen it's come up in the chat. I know we've had a few discussions on it, is whether or not, as insurers, we are able to pick up those the POPI-related fines. And I know it's the policy caters for it to the extent insurable by law, and we've been kind of waiting to see. We've only got one fine out, so it might still be too early to tell. We may need a couple to see whether or not insurers will be able to pick these up. So that's the one part of the question, and I just like to then give a shout out to Marnell Ward, because the question was, or would a DNO policy be there to kind of pick up the fine if the director's offices decided not to respond appropriately? So no, that's not what the DNO is going to be there for. But if I can put the question around, can a cyber policy pick up these fines and penalties as we see it standing at the moment to you, if there is an answer as yet?
It's a great question. It's something that's just coming up repeatedly at the moment. I mean, look, the starting point in terms of our law, as we understand, in respect of a fine or a penalty, is our courts will look at whether it's against public policy to provide for an insurance indemnification for a fine or a penalty, bearing in mind that often they have a punitive or penal element to it. It's meant to penalize parties, and on that basis, we think that our courts might well align with the view that it's not insurable, but it's something that will have to be tested in due course. The point you make, though, about the DNO knock-on effect is a very, very important one, though, because let's say, for example, a responsible party is met with a fine and is required to pay that fine, but then turns around and looks at its individual DNOs, including the information officer, and says, through your negligence, we were met with this regulatory fine, and we now bring a damages claim against you, a derivative action or the like, seeking compensation. And we can see that there would be a very interesting debate within a DNO policy as to whether that damages claim might trigger the operative clause under the DNO policy. But Ryan, at the very least, what we think it would do is trigger the defense costs provision, because those individual DNOs might well call upon the DNO policy for defense cost cover in order to deal with that sort of claim by the company itself. So it's a very interesting scenario, and we think we are going to see some activity in that regard, and hopefully in time some case law and authority that might shed further light on it.
Thanks, Lee. It's a great answer, and it is an interesting question. So I think we've got interesting topics as far as the risk landscape is concerned, and then to couple onto that, interesting topics as we see how the legal and regulatory frameworks also piece together, and we get some case law around that. I see we are at the top of the hour, so I just want to thank our colleagues from Clyde & Co for making their time available and sharing with us their expert insights and expertise. We do always appreciate it. You guys are a valuable part of our response team, so thank you for making the time available. And thank you to the brokers who attended as well. We hope you found the session insightful and look forward to engaging you further.